The Department of Justice was formed after the 2013 elections. This was after the Ministry of Justice was merged with the Office of the Attorney General. The department therefore organically carried out all the functions that were undertaken by the Ministry of Justice. The Legal Affairs Division under the Department of Justice is consequently positioned as the critical policy-making arm of the Office of the Attorney General.
If you look at the executive order, there are some issues that have, that the Office of the Attorney General and Department of Justice has been mandated to oversee. And these would be issues to do with human rights, issues to do with ethics, anti-corruption, issues to do with the Constitution, constitutional implementation, constitutional development. And when you're talking about the Constitution, the constitutional development, then in a sense you can say then the issue of constitutionalism, the custodian of that rule of law basis is the Department of Justice. Issues to do with transitional justice. What do we mean transitional justice? You remember after the 2007 issues that we had, there were a lot of things then that that had to be undertaken to ensure that the country then was on the right track. These are the issues we are referring to as transitional justice issues, historical injustices. There are very many Kenyans that do not, cannot afford lawyers, and justice is expensive in all countries of the world. So the government's then aim is to ensure that everybody has access to justice. So the policies then relating to provision of legal aid. And when you're looking at policies, you're saying, what is it that people can say the government has decided to do or not to do? This is what we call, policies. And that's why you talk of, you have national policies, you can have sectoral, policies relating, for example, to certain sectors. But when you're talking of national policies, you're saying these are policies that bind the whole country, that, the scope of these policies is national, the whole country. When you're talking, for example, on policies of human rights belong to each and everyone. So the policies that then you develop must be applicable to everyone.
Over and above, the department also makes proposal changes of law, advise other ministries, departments and agencies on the legal implication of their actions on the mandate areas.
For example, evicting people. What is the impact on human rights? Yeah. When there is an integrity issue, what does the Constitution say about this? What are the expected outcomes? So for at any given time, when you have national policies, then you're telling Kenyans, my government is predictable. On this issue, this is how the government will proceed.
When drafting policies, be it at the county or national level, public participation and stakeholders' involvement is very fundamental. It is one of the values that is provided for under Article 10 of the Kenyan Constitution. The Department of Justice has time and again gone to the grassroots to interact with the stakeholders and develop policies that the people can easily relate with.
I'll give you an example of the national policy on human rights. This is one of the policies that the Ministry of Justice had embarked on. And one of the great successes of that process is that this national policy on human rights process is actually what, to a large extent, informed the Chapter 4 of the Constitution that you see today. It was one of the processes that set precedents of how policies should be developed. We went everywhere, throughout the country, and the model we took is that we would have people. If, for example, we are going to Kapeguria, if we are going to Mashuru, wherever we are going, you have civil society organizations on the ground who educate people on what it is that the government is doing, what the policy is intended to do, and they help people articulate what their needs would be on the ground and what it is that they would want prioritized in a policy on human rights. So by the time now the steering committee is going to the ground, the community already has information and is able to engage with the process. Because if people then don't have information, if people do not know what they're supposed to do, that is not meaningful public participation. But we have done a national policy that then explains what meaningful public participation is.
Using public participation process as a yardstick, the Department of Justice has made great milestones in carrying out their mandate.
Some of the landmark policies we've made is one, the National Policy on Human Rights. We also have the National Ethics and Anti-Corruption Policy, and you know the impact that has, and you can see the fruits, the outcomes of that policy. We have also now developed the National Policy on Public Participation, defining, because everybody say public participation, but what is effective public participation? We have done that. We have also, we have also facilitated the development of the National Legal Aid Policy, finding who is it that deserves to be given legal aid by government. We have also developed a policy, what we're calling an action plan on business and human rights. And why did we think this was an issue? Because with all the oil, the mining, all the things that are happening, all the power that businesses have, how they impact on on everyday life. So that is actually something that we are very proud of. When we are saying, if you look at the Constitution says that everybody must respect human rights. And when they say everyone, every person, a person includes a company as well. So these are businesses. Much as we were saying that it is the government's duty, to protect and promote human rights. But you and I too got obligations in the sense that your duty, your right begins where your duty ends, isn't it? Because everybody, we must know how we impact on human beings, because everything we do really is for human beings. We try as much as possible to have what we call a human rights-based approach to policy formulation. And what this approach, largely, states is that everybody must count. No one should be left behind. And in a special way, the most vulnerable people, the people who will be impacted on most, must really have a say. If you think that there is a gray area in our mandate areas, I'll give you an example of, for example, the intersex persons. Much as even the individuals will you find, for example, like the intersex persons case, where you'll have a child has been born. The doctors cannot determine whether this child is a boy or a girl, and it's a natural phenomenon. So what happens? The child does not get a name. So the child is named baby. Where the sex is supposed to be male or female, it's put X. So which means then the baby can't get a name because it's you don't know whether it's a boy or a girl. So you find people will litigate this and say, is it legal for a baby not to be given a name? For a baby to be marked X because you can't determine what it is, and the court looks at it, determines that you need to have a policy. You need to look at this issue and determine what happens with such such children. So the Attorney General picks up that as an issue that ought to be a policy agenda item, and you start the process of actually consulting people, okay, including the intersex persons themselves. What are these issues that you want, addressed, so that then, you articulate policy directions of the same. You say we need to be able to identify ourselves. Yeah, if I'm born with, I'm not typically a man or a woman, I ought then to wait until I am an adolescent, determine, I can have some tests and determine I'm more of a man, and therefore self-identify as a man, or the test can prove that I'm more of a woman, therefore I can self-identify as a woman, and I should be able to change then my name. I should be able to change my sex if I want to be identified as male. But if I want to remain as intersex, there's nothing legally wrong with that, because that's how I have been born. I didn't choose to be born that way. And if you remember, that is why the government, then having taken a stand on this, during the last census, we had 3 markers, identity markers. You could mark your male, female, or intersex. Yeah, because and that is something. It is something unprecedented. You realize that the more you consult people, the more they become aware, and the more they demand. So I may consult you today, and when you go back, think about it. You have understood the issues better. You feel I need to consult you again, but resources are limited. Resources are limited, and you have to, for example, look for partners to, institutions and organizations to partner with you, so that you're able to walk further. So the element of always feeling we were not consulted enough. And when for example, like when we were doing this policy on business and human rights, we went even up to Turkana, you'll sit down, for example, with Tulo and the local communities, and you can have an understanding, but at some point, one of the parties will still feel like no, there is an element that ought to have come in, but you cannot, in policies, you cannot have everything. And I think majority of then individuals as well, they have difficulties in differentiating what should be policy issues and what should be administrative issues. And when you tell them, no, the government does not have to pronounce itself on every issue. It is only that issue, that they have to, to clarify to individuals that this is the government stand and this is what the government will do. And you remember, the government will only now pronounce itself on issues, again, that are grounded in law, are grounded in the Constitution. So not every issue will become a policy issue.
Because of the comprehensive nature of policies, the department is further subdivided into 3 sections, which are the human rights and legal education, constitutional implementation, democracy and good governance, and anti-corruption, ethic and integrity sections. We would want to be a department that's responsive to emerging issues. Like now you'll find with these issues on referendum and everything, we must be on our toes to ensure that the advice that we give is timely and again is based on the law. So we do not want to, play catch up, because we should always be on top of our game, so that at any given point, if there's an emerging issue, the citizens should be able to know, oh, but this is what the government has, this is what the government does, this is the government's stand on this issue. So we must always be on top of our game. And realizing that one of the constitutional mandates of the Office of the Attorney General is advice to the government.
So, this advice, must be grounded on policy, must be grounded, on the law. So it must be something objective, something that the Kenyans can believe in.